Hello everyone, welcome back to SQE One Window. We will be talking about remedies today. So, to dive into civil remedies, or as I like to call it, how the law sorts out when people are unreasonably inconvenient. So, remedies are the court's toolkit for putting things right when they are wrong. They come into two flavors: legal remedies, which you get as a matter of entitlement or right, and equitable remedies, which are the court's discretions. Think of equity as the VIP section of remedies. You don't always get in, but when you do, it's very satisfying indeed. By the end of this session, you shall be able to advise clients, answer exam questions, and perhaps impress your friends at dinner parties with your knowledge of injunction and different remedies. So, to talk about remedies in contract, the main remedy is damages, compensation, the money matters. The aim is to restore the claimant to position they would have been if the contract had behaved itself, or it was performed itself. We call this protecting the expectation interest or expected interest, essentially. Getting what you bargained for without any dramatic courtroom punishment or courtroom sanctions. Heads of damages include expectation loss, reliance loss, and restitution. Remember Hartley case to you? Losses must have been reasonably foreseeable. That's one of the conditions. So, in other words, if you forget to deliver the flower for the Queen's wedding cake, don't expect the court to award damages for heartbreak across the nation. Not at all. It should be foreseeable damage only. And watch out for liquidated damages clause. The court will enforce them only if they are genuine, pre-estimated, or estimates. If it is extravagant, it's treated as penalty, and you might as well have thrown monopoly money at the wall. So, no punishment, only compensation in tort. In contract. And let's talk about tort as well. So, tort damages are a bit like rewinding the clock. They restore the claimant to the position before the mischief. We have nominal damages, basically a polite, "you're right, well done," and maybe a fiver high five. Then we got contemptuous damages, are even tinier. It's not like very high, awarded when your claim is technically valid but really should never have been brought to court. Think of it as the legal equivalent of being told, "Bless your heart, but that was a bit pointless. There was no point coming to court." Then we got aggravated damages, and that is to compensate for insult to feelings or dignity. While exemplary damages are rare, reserved for behavior so outrageous, the court says, well, that deserves more than a slap or the wrist. So keep in mind Rook's case. So examiner love it at that point in order to talk about remedies in tort law. So classification of claim. Claims are either specified or unspecified. Specified sums are like a £50,000 unpaid invoice. Unspecified sums are more mysterious. The court has to figure them out, that how much they should award, like trying to guess how much tea to brew for a royal garden party. Some claims are a mix, like ordering fish and chips with a side of mushy peas. Always clarify which part is which in your claim form. So sometimes something defined and something undefined, or risk confusing everyone involved, including the court clerk at that point. So you need to specify what you want. And if it is not, court will determine it. And in some cases, you might lose what you want to claim out of it. Then we got equitable remedies. We have talked about legal remedies. Let's talk about equitable remedies. When damages or compensation want to, we go equity. When compensation is not sufficient or adequate, equitable remedies, they come in. So the first one is rectification. Correct the contract. Amend the contract to reflect what people actually meant, like fixing a typo in the Queen's speech or King's speech. So next is specific performance. What does it mean? Force action, but only for unique things like land or van. Sorry, you cannot force someone to tidy their office, like my office. You can't force me. Specific performance, once again, it only works when compensation does not work. Then there is rescission, the legal undo button. Contract set aside. No question asked. Contract is gone. Restitution restores what was transferred, preventing unjust enrichment, that you got a device and you did not pay for it. So at that point, it is unjust enrichment. You cannot use law as a tool to defeat other people's interest. Another thing that is equitable is declaration. The court basically says, this is what the law says. Get used to it. So those are equitable remedies. And now my favorite, that is injunction. Injunction are the legal equivalent of shouting. Stop that this instant. Stop it now. Do this immediately, for example. Do it, and that's what you need to do it. The number one is prohibitory. Don't do something like don't trespass or post defamatory tweets. Or don't do this TikTok video. It will defame someone. Mandatory, like do something like remove a dodgy fence or pay what you owe. Do it now. And another injunction is quae time injunction, and that is Latin word. Maybe I don't pronounce it right because we are nervous stopping harm before it happens. Like, if something is going to happen and court says stop it. So in exam, remember American cyanamide. The principle are gold: discretion, adequacy of damages, balance of convenience, and yes, they really like the case. So at that point, you need to understand which remedy will work, like, legal, equitable. And in equity, we have gone through different remedies and why injunction will suit on certain cases, in certain cases. So another thing is interim injunction and undertaking. Interim injunction are temporary granted pending trial. They come with cross undertaking in damages, basically a promise to pay if you were overzealous. Equally important, full and frank disclosure. If you mislead the court and your injunction is toast, equity is likely a strict teacher. Dishonesty will not be tolerated and you would have to compensate. Then we got freezing order or Mereva injunctions. For the fancy legal type, prevent the other party from spending or moving assets. Requirements are strict, jurisdiction, just and convenient, good arguable case, assets exist, real risk of dissipation of assets, cross undertaking in damages. If you are wrong, you will pay the damages. And then you need to have a full disclosure. All these conditions are met. At that point, you can ask for freezing order. Don't let them spend something because my right is tied with their asset. Think of it as putting your opponent's money in a giant legal ice cube until the court decides who gets it. And yes, if you break it, you can go to jail. So don't shake it or try to melt it early. Search orders. That's another thing. So these search orders, previously called Anton-Pillar orders, are likely legal home invasions, but in a very polite and supervised manner. Used when evidence might be destroyed, and their conditions are jurisdiction, just and convenient they should be, extremely strong case to make search orders, serious potential damage if they are not granted, evidence exists, no other way to get it. There is evidence, no other way to get it but by the way of search orders. Or there is real risk of destruction, cross undertaking, and damages. Once again, you need to give. If you don't, if your case was not successful, you need to pay damages. Once again, full disclosure. You need to disclose everything to the court before these extraordinary search orders are granted. Safeguards include supervising solicitor. Solicitor will supervise all that activity. There will be restricted attendance and protection of privileged document. And if there is a breach, there will be contempt of court. And yes, the supervising solicitor will be watching like a hawk what's going on. You cannot sneak in or sneak out with evidence. The court frowns on ninjas. So our favorite, the next one in remedies, we need to understand about SQE preparation on remedies. So my tips are always distinguish contract versus tort remedies. Those are two different things, and the purpose of both of them are different, as we have already explained. Know your type of damages. Number 3, equitable remedies. Understand when damages are inadequate. That's golden rule. Injunction and interim remedies, cross undertaking, and full disclosure are crucial elements which are tested in SQE questions. Freezing and search orders, those are very strict, and the conditions are very strict for grant of freezing or search orders because the stakes are high. So common pitfall that people got like in SQEs, misclassifying sums, confusing remedies at some point, and trying to think that there must be something punitive. There is nothing punitive in civil cases. It is always compensation or certain equitable remedies to protect interest of people, masses. Thank you very much for just I hope it makes sense. To further understand it better, I would point you to our notes, which are thorough, and you will understand it, and also question bank to test your understanding. Thank you very much. Ta-da.